Well, good afternoon, everybody. Well, it's a great pleasure to be here in this outstanding symposium at Oxford. I'd like to thank Andrea and Filippi for organizing such a joyful conference, and I'm sure we'll keep up with the same outstanding as we had in the previous panels. Our panel, we will have basically 3 rounds of conversations into the different questions that come up with the main topic of class arbitration, especially in the investor-company disputes. Shortly speaking, we'll have a first round basically laying down the legal framework for protection of investor-companies disputes in the different jurisdictions represented in this panel. Then we will address the class action, in particular class arbitration in that scenario. And thirdly, we will have the challenge that we are facing with this class arbitration, in particular procedural challenges. I first would like to introduce all the panelists, since we will have a roundtable kind of discussion, so they don't need to introduce every time each of them. I have here Andreas Hacke, who is a partner at ZHMP in Germany, Düsseldorf, and he's also a visiting lecturer at Oxford University. David Orta, who is a partner and the head of the International Arbitration Practice in DC and Latin America at Queen Emmanuel DC office, and Pedro Barroso, the head of the International Disputes Group in Petrobras, and Sophie Lamb-Quissy, partner and global co-chair of the International Arbitration Practice at Leighton Watkins London office. So firstly, to level the playing field and set up the legal framework we are working, I would like to ask all the panelists, what are the legal protections available to shareholders in companies' disputes? In particular, I would like you to address the arbitrability of investor shareholders or investor company disputes, and also how common it is to have arbitration agreements in bylaws or in shareholders' agreements in your own jurisdictions. For that, I will kindly invite Sophie to start addressing the standards in the UK. Please, Sophie.
Thank you very much. Good afternoon, everyone. So I'm looking at the position under English law, and as many of you will know, London continues to be, and has been for a long time, a preeminent seat for international arbitration, and English law has remained a dominant law for international agreements over many, many years. And the vast majority of public companies, listed companies, certainly within Europe, are listed in London. And indeed, the vast majority of the listed companies in the world, if you exclude the United States, are listed in London. Yet despite all of these things, the arbitration of inherently company law disputes, and in particular shareholder grievances that pertain to public companies, is not something that has been a dominant feature, or even frankly a feature at all, of English law and of modern arbitration practice. And throughout the panel discussion today, we'll come on to discuss some of the reasons for that. The first question, though, that we are asked to address is the sort of more fundamental question: are these disputes in principle arbitral? Are they consistent with public policy? Are they prohibited by any rules of arbitrability in the various jurisdictions? So the position under English law is, broadly speaking, as follows. Of course, shareholder agreements as such are contracts, and therefore they are subject to the will and the choice of parties. So certainly, so far as private companies are concerned, there is no prohibition whatsoever in having an arbitration agreement in a private shareholders' agreement. Conceptually, memorandums and articles of association, so the fundamental constitutional documents of a company, are also seen as a matter of English law, though not recognised in legislation as such, as contracts or quasi-contracts. So again, in principle, there is no reason why shareholders in public companies could not agree to have their interests in those companies regulated by arbitration rather than by the court system. The question has been put to the English court, though it wasn't until actually quite recent times. The primary case is one involving the Fulham Football Club. And in that case, the court was asked to consider the question whether allegations that the company was being run unfairly and to the prejudice of a minority shareholder could be put to arbitration. And you might sort of wonder why it was that it took so long for that question to find its way to the court. Well, English company law, the sort of modern variant of company law, dates back to the middle of the 19th century. It sort of coincides with the Industrial Revolution. And the rights and remedies of shareholders have been so well, if you will, legislated. They are the subject of rich case law, full of examples, full of precedents. And the sorts of powers that a court has in the context of a grievance of a minority shareholder who believes that a company is being operated to his or her or its prejudice are set out very clearly. They are wide-ranging powers, and many of them do operate to the detriment of third parties. So in particular, there could be a remedy that somebody be bought out, and in extreme cases, that a company be broken apart or wound up. And of course, these are all remedies that have impacts on a wide range of actors, and those go beyond just the members of the company. So for those reasons, I think that there had been a commonly held perception, at least, that disputes involving the rights and grievances of individual shareholders in public companies were not, if not unarbitrable, at least not really suitable for determination in arbitration. So when the question was put to the court, it was actually quite an interesting analysis, because the court's instinctive reaction was actually that there was no reason in principle why that sort of dispute couldn't go to arbitration. And in fact, it was both suitable for arbitration and certainly not prohibited to be put to arbitration. It drew a distinction, however, between arbitrability as such and the suite of remedies that an arbitral tribunal might be able to deploy. So looking at those remedies which fundamentally impact on the rights of third parties, they are very much within the exclusive competence of the court, and it's only a limited range of remedies that an arbitral tribunal can use. So that's broadly the position under English law. And in the next round of questions, I'll talk to you a little bit about why I think class action arbitration, shareholder arbitration as such in public companies really hasn't taken off in the UK.
Thank you, Sophie. So to continue with Europe, let's see how Germany deals with the issue.
Yeah, thank you, Flavia. And let me first also thank the organizers for inviting me to this wonderful event, and for you to organize the panel as you did. In Germany, it is quite, at the outset, quite parallel to what we just heard from Sophie to the UK situation. So the question of arbitrability of disputes amongst shareholders or other corporate disputes can be answered in the positive. In general, they are arbitrable. That's the broad general rule, because under German law, all proprietary claims, as it's stated in the German law, are arbitrable, and that means that all claims which are linked to, in the farthest sense, to property issues and corporate claims, corporate disputes count to that definition. So they are arbitrable in general. However, there are certain limitations to that which need to be taken into account when you look to the German legal environment. First, there are a few special provisions and special laws in the banking and finance sector which exclude certain claims out of these sectors from the arbitrability, but they don't have such a broad applicability that they are of a broader general interest. Secondly, it depends very much at what kind of company you look at. In German corporate law, you have a broad distinction between corporations on the one hand and partnerships on the other hand. That's the very broad distinction. So corporations we would call the stock exchange stock corporations and the limited liability corporations, and partnerships, there are numerous groups of partnerships under German law. And the general concept is that a corporation and the bylaws of the corporation are detached from the shareholders or the members, if you so like, of the company, and form a very, very individual legal body, so to say, whereas the articles of association of a partnership are very closely linked and tied to the individuals being members to that partnership. And that has consequences to not the arbitrability in a legal sense, but to the legally valid scope of an arbitration agreement that you may find in articles of association of any of these two types of companies. So under German law, it is absolutely okay to have arbitration clauses in the bylaws of a corporation, and that would even bind people who join the corporation or who buy shares of that corporation after the inception of that company and who have not themselves agreed to that specific set of articles. Whereas in a partnership situation, it's quite the contrary. There, the German courts say that an arbitration agreement within the bylaws will only bind upon those partners that have either been already there at the time of inception of the company or who have later agreed specifically to that arbitration agreement. And that leads to partnerships in Germany that generally having separate arbitration agreement besides the articles of association. That's the general starting point, so to say. Taken from that, however, we have to look at further limitations to not so much the arbitrability, but again to the scope of the validity of an arbitration clause within bylaws. And that has come along with a series of decisions by the German Federal Court of Justice, the highest court in civil law matters in Germany. And mistakenly, these cases are called arbitrability 1, arbitrability 2, and arbitrability 3. However, if you look at it in detail, they don't really deal with the arbitrability of the issues at stake, but rather with the legal scope or the validity of the arbitration clauses to be found within these articles of association that were the subject matter of these cases. So what has the German court then elaborated as a set of rules in order to allow a arbitration clause to cover disputes amongst shareholders? First of all, one has to say that the applicability of these decisions is limited to disputes about shareholders' resolutions. So the resolution being taken by shareholders, and some of the shareholders don't agree to that resolution, they want to tackle that, and so they ask themselves, can I take that case to court, or am I bound by the agreement to arbitrate, which I find in the Articles of Association? And only limited to this class of disputes about shareholder resolutions, the German Federal Court of Justice has ruled that we need 5 prerequisites in order to allow these clauses to apply to the shareholders. Contrary to what the general rule is, the first of these prerequisites is, according to these judgments, that all shareholders have agreed to take the case to arbitration. So that's contrary to what I said earlier. Generally, the rule is that within corporations, you don't need to have a specific agreement by all the shareholders. However, the German courts say when it comes to disputes about shareholder resolutions, this rule is flip-sided, and we do need an agreement of all shareholders to take that case to arbitration. That can be in the articles, or it may be in a later agreement to arbitrate amongst the shareholders at whatever time prior to the initiation of the arbitration. Second prerequisite is that it must be provided an equal level of protection to all shareholders, and I'll come to that later during the discussion. Third, all shareholders, but also all organs of the company, like the directors, the managers, and so on, must be informed of the arbitration and must have a chance to join it. So that's a very important prerequisite, and that also links to concepts in the US law that we will look at later, perhaps. Fourth, all shareholders must have the possibility to have some kind of influence on the choice of arbitrators, although it is admitted under German law that groups of shareholders may choose arbitrators, for example, by majority vote. This is admissible, but at least they need to have some kind of, be it diluted, influence on the choice of arbitrators. And fifth and last, all disputes about all resolutions concerning the same subject matter must be channeled to the same arbitral tribunal under the applicable rule of the Articles of Association. So, for example, if you resolve to dismiss a shareholder from the company and there is a subsequent dispute about his severance payment, then both of these disputes must be handled by the same arbitral tribunal. If these 5 prerequisites are met, then it's okay.
Thank you, David. So moving to the Americas, I will ask Pedro to share with us the legal framework in Brazil that might explain why there is a hot topic there right now.
Sure. Thank you, Flavia. It's a great honor to participate in this event. I'd like to thank André Luiz Monteiro and all the members of the organization board for the invitation. I have to make a brief disclaimer. I'm not speaking on behalf of my employer, Pedro, but and the opinions I express here are my own opinions. As anticipated by Flavia, I'll try to present the Brazilian law perspective over this very hot topic right now of class arbitration and investor company disputes. I'll begin by saying that there's no real controversy that investor-company disputes are arbitrable under Brazilian law. Article 1 of the Brazilian arbitration law provides that anyone with legal capacity to enter into contracts may submit to arbitration claims involving economic interests that can be disposed of. Disputes between a company and a shareholder will very likely fall under that category. One interesting discussion, though, that has now been resolved in Brazil, but it's still interesting, is whether the bylaws of a company can validly provide that shareholders' claims shall be resolved by arbitration. I know that this is, of course, very different to providing for class arbitration of investor-company disputes, as I'll explain later. So moving to the bylaws arbitration agreement. Back in 2001, the Brazilian Congress enacted amended their corporate law to provide that the bylaws of the corporation may establish that disputes between the shareholders and the corporation or between the controlling shareholders and the minority shareholders may be resolved by arbitration. Starting in 2002, the Brazilian Stock Exchange created special trading segments such as the New Markets and B3 Level 2 that are only available for companies that have higher standards of corporate governance and transparency. One of the requirements to be admitted in these special trading segments is to include an arbitration clause in the company's bylaws. The arbitration agreement shall provide for arbitration administered by and under the rules of an institution called the Market Arbitration Chamber, which was created by the stock exchange. Over the years, 170 publicly traded companies were admitted to these special trading segments, and the end result is that today the bylaws of most of the major Brazilian publicly traded companies provide that disputes with shareholders shall be resolved by arbitration. However, nothing is simple in Brazil. Controversy arose with respect to the enforceability of the bylaws arbitration agreement. As the discussion was over specifically shareholder consent to arbitration. The main question was whether such agreement could bind shareholders who voted against the corporate resolution that included the arbitration clause in the bylaws, shareholders that abstained to vote on such resolution, or investors who purchased their securities after the amendment of the bylaws. One group of law professors argued that corporate bylaws are contracts of adhesion, and therefore the arbitration clause would have to follow specific and qualified consent requirements under Section 4, Paragraph 2 of the Brazilian arbitration law. As a result, bylaws arbitration provision will only be binding on shareholders who expressly consented to arbitration in writing on a separate agreement with the company. But the majority of the scholars did not see problems with the bylaws arbitration agreement. In opposition to the minority, they argued that the bylaws constitute a multilateral contract of organization that sets down rules and procedures about the affairs of the company and binds each party. Such contract is governed by corporate law, which is based on the majority rule, meaning that a resolution approved by the majority of shareholders is binding on all of the shareholders. And investors consent to arbitration just as they consent to any other provision of the bylaws when they make their investment decision and purchase their shares. Over the years, the majority's view eventually prevailed. In 2012, the Federal Justice Committee organized the first commercial law conference with the participation of 172 leading Brazilian scholars. And one of the propositions approved in that conference was that the purchase of the shares in a company is bound by the arbitration provision in that company's bylaws, regardless of the existence of specific consent in that regard. Thus, these law experts opined that shareholders manifest their consent to arbitration by purchasing shares of the company. In 2016, the controversy was finally resolved for good in Brazil. Brazilian Congress enacted Article 136B of our corporate law that confirmed the consensus by providing that approval of the inclusion of an arbitration agreement in the bylaws in compliance with the applicable quorum binds all shareholders. Dissenting shareholders have the right to withdraw from the company and shall be reimbursed for the value of their shares unless the inclusion of the arbitration agreement is implemented to fulfill a requirement to be admitted in special trading segments, and the shares have liquidated, and the company's shares are ownership is dispersed. Interestingly, the arbitration clause in the Petrobras' bylaws has been the subject of litigation in the United States before it was ever discussed in Brazil. Petrobras is an oil company that is also listed in Brazil and also in New York through an ADR program. On February 30, 2015, District Court Judge Jed Rakoff issued a ruling dismissing all Brazilian law claims filed against Petrobras in a securities class action. Lead plaintiff there tried to represent purchasers of shares on the Brazilian stock exchange in addition to US purchases of ADRs. The claims predated 2016, so were not covered by the changing law. But after a thorough analysis of competing Brazilian law expert opinions filed by the parties, Judge Rakoff found that the arbitration clause was enforceable and all shareholders were bound by arbitration with respect to their Brazilian law claims. Therefore, the class action proceeded only with respect to US securities laws claims of ADR holders and Monde holders, which the court found were outside the scope of the arbitration agreement. I believe it could not have gone the other way, given that there's complete consensus on the issue in Brazil, and a finding that the clause was unenforceable would mean that the bylaws of more than 170 Brazilian public companies have had an unenforceable dispute resolution provision for many years. Based on these comments, under Brazilian law, there isn't any discussion about the arbitrability of claims between a company and its shareholders, and there's no longer controversy that arbitration clauses in bylaws are valid and binding on all shareholders. But that is not the same as saying that there is class arbitration under Brazilian law, as I will explain later.
Thank you, Pedro. David, how are provisions in the US?
So good afternoon, everyone. Is this working? So firstly, just thank you to the organizers for the very kind invitation to come and speak here, and to Flavia for kindly organizing our panel and keeping us all hopefully organized for the rest of the event. So the United States, I'm going to just talk very briefly about the framework for arbitration in the U.S. and in particular in relation to shareholder disputes against companies. Firstly, there's a firm policy in the United States encouraging arbitration, and that is rooted in a federal law called the Federal Arbitration Act. You've heard it mentioned already in earlier discussions today, in our earlier panels. And the broad public policy is that if parties consent to arbitrate a dispute, then that agreement and consent will be upheld by the courts. And in particular, there have been a number of challenges that have gone all the way up to the U.S. Supreme Court, including, for example, in circumstances where states have implemented laws barring certain issues with respect to arbitration, and the United States Supreme Court has consistently applied the following principle, that if parties have unmistakably agreed to arbitrate a particular kind of dispute or to have their arbitration conducted in a particular kind of way, that will be respected. And I'll speak about class arbitration when we get to the next question. But that's the broad principle, and that's been firmly upheld in a number of cases in the United States. And I'll mention some of the leading cases in the next section of our panel. In relation to whether shareholders in public companies can submit their claims to arbitration, the answer is under U.S. law that they can. And in fact, they do, under the NASD, National Association of Security Dealer rules, and then its successor, FINRA. The rules allow for arbitration. It's common to have arbitration of disputes between investors and companies. And again, when we get to class actions, there are some interesting distinctions in relation to whether class arbitration can or can't proceed in relation to investor claims against companies and limitations on what companies can and can't do in that sphere that don't necessarily apply to other sectors. In short, the issue of class arbitration, of investors' ability to proceed with arbitration is controlled by the FAA, and in particular also in relation to shareholder disputes by FINRA's rules, which specifically allow for arbitration of such claims. I'll stop for now, and then we can
Perfect.
go to the next issue.
Well, now that we have nailed down like the legal framework where we will start our discussion in the next session about class arbitration, in particular in that area of investor companies or shareholder companies disputes, I would first invite the audience if you have any questions or any comments on how these issues are dealt with in any particular jurisdictions that were not addressed in the panel. Well, in the morning, people were more interactive. That's maybe the sugar high didn't really kick in. Well, I think we have Peter here.
Maybe just one remark. The reason why the German Spirit Court invented these 5 requirements is to apply the erga omnes effect, which is explicitly regulated in the law and which we don't have in Brazil. So that's
yeah, I think we'll get there in our third panel because we will discuss all the procedure issues that comes from having a class arbitration and the effects of an award, and probably that will be discussed, I think, in the last panel, but it's good to understand as well. Do you want Andreas to comment on that? No.
No, it's okay.
Any other questions or comments? So I think we can move on to actually the main topic of this panel, that's actually the availability of class arbitration in the context of investor-state disputes, and then also what is the concept of class arbitration. We have a lot of multi-party arbitration actually involving several parties that sometimes are called as class arbitration, and then we have more of a US type of class arbitration where you have an association or any type of representation of a whole class, and then it comes with all the procedure aspects thereof. But since I think this big discussion started in the US, I will give the speak back to David so that you can start sharing with us how the class action started in the US in that area.
Sure, my pleasure. All right, so the United States, in fact, has been the maybe the motivator or leader in relation to the pursuit of class actions. And that started with the promulgation of a rule under the Federal Rules of Civil Procedure called Rule 23, which in essence establishes 4 requirements for class actions to proceed against defendants, normally big companies. And the underlying principle behind the class action is that, generally speaking, the individual claims are, by and large, not significant enough from a monetary perspective to pursue alone. And so, in order to promote access to justice, the U.S. laws allow the amalgamation of claims, provided, again, you meet certain requirements, to be pursued against companies. And the idea being that when you amass a large number of claims that are all very similar in nature and in scope, that then gives the ability of those who have claims but wouldn't otherwise pursue them on an individual basis because it might not be financially viable, to hire lawyers and bring the claims against the defendants. It's a very controversial topic. And there's sort of a really interesting philosophical discussion that we could get into about class actions and whether they really promote the interests of the individuals on whose behalf they're brought. By and large, they tend to promote the interests of the lawyers who bring the claims, because they end up making a lot more money than the folks who maybe get a check for $8 or $9 at the end of the day as part of the class action. But in any event, the issue of class arbitration springs from the ability to bring claims in federal court under Federal Rule 23. And there's a decision back from the 1980s, Southland versus Keating, which is a U.S. Supreme Court decision in which the question of whether one could pursue class actions in the arbitration context was raised with the U.S. Supreme Court following a California state law that allowed for class claims to be brought in the arbitration context. And the U.S. Supreme Court, in essence, said, look, absent there being some waiver of class actions in the arbitration agreement itself, there's no problem with pursuing class arbitration of claims in arbitration, in the arbitration setting as opposed to the court setting. So the answer is yes, it can happen. That has led to a series of very interesting cases that have ultimately come before the U.S. Supreme Court regarding when and what needs to, or what precisely needs to be in an arbitration agreement in order to find that class arbitration is viable, and then separately, when can parties waive their right to arbitrate class claims? In the Green Tree versus Financial Corp v. Basel case, which was a 2003 case, the court basically held that, again, absent there being a waiver, the decision to arbitrate class claims will be respected by the U.S. Supreme Court, provided that there is a clear agreement to arbitrate. The issue there is that the court didn't define what a clear agreement is, didn't say whether it could be or needs to be expressed, whether it needs to be implicit, whether it could be implicit, which led to a number of really interesting cases and decisions. And I don't have the time to go through them all now, but basically there are two guiding principles that have come from these cases out of the Supreme Court. One is that, and this is sort of the bedrock of how federal courts in the United States and state courts view the issue of arbitration in particular. The principle of party consent is upheld, right? So if parties decide that they want to arbitrate class claims and there's a clear expression of that in the arbitration agreement, that's going to be upheld. Where the next interesting question comes is where you have an arbitration agreement that doesn't really say anything about class arbitration. Then the question is, how will the courts in the United States deal with that? And the upshot, after many, many years of this being litigated through the U.S. Supreme Court, and it's still, I would say, an area of law that is developing in the United States, but it's somewhat mature, is that after a series of decisions, Oxford Health, AT&T, Mobility versus Concepcion, and a number of others, where we have landed as of right now is that class action waivers will be respected in virtually every circumstance except one, which is shareholder claims against public companies. And the reason that there is an exception to that is that the FINRA, which is the agency, the federal agency that overlooks public broker-dealers and basically is there to fight for the rights of investors and ensure that broker-dealers are doing their job right and respecting the SEC rules. They come within the umbrella of the Securities and Exchange Commission. They have a rule that says that it is prohibited for broker-dealers to include in their agreements with their clients, with their investors, a waiver of class actions. So, and the reason that that's there is that because many times, again, investors have claims, but they're too small in terms of the monetary amount for them to really justify hiring a lawyer to go after them, to go after the broker-dealers. So FINRA introduced a rule that basically precludes the class action waiver, and that has thus far been respected by the U.S. Supreme Court. Contrary to various other sectors, and I'll end with this, various other sectors including phone contracts, employment contracts, where states, for example, have promulgated similar rules trying to prohibit waivers under the concept, class action waivers, under the concept that these are adhesion contracts, that the consumer doesn't really agree, doesn't really negotiate them, they just sort of have to accept them. But the U.S. Supreme Court has repeatedly, in a number of cases, including AT&T Mobility versus Concepcion, Stoltz-Nielsen's another case from the U.S. Supreme Court, and they have repeatedly found that where you have these agreements with class action waivers, those will be respected.
Thank you, David. So just to reinforce what we had in the first panel showing that like cultural differences are not binary, common law, civil law, I asked Sophie to explain to us how these things are dealt in the UK.
Thank you. So as I explained in my introductory remarks, that there is no practice of class action arbitration in disputes involving shareholders in UK publicly listed companies. And the reason for that has nothing to do with arbitration law as such. There's no impediment to that, as I explained in my opening. Instead, the reasons are to be found in our company law and also in our rules of civil procedure that govern the practice of litigation. So turning first then to substantive law, so of course the law that regulates the operation of a UK-listed company is indeed English law. And in our company law, the law does not give rights to shareholders that they can directly enforce against companies, boards, directors, or related third parties. So there's a fundamental standing problem for an individual shareholder who has a grievance with the board. At most, a shareholder with the court's permission can bring a derivative action, but in doing that, they would be stepping into the company's own shoes. They would be given permission to act for the company in order to question the conduct of the board. So standing is a fundamental problem, and that's why we just do not have the practice of securities litigation as such that you see in the United States. And I suppose related to that, we don't find matters of corporate governance in hard law as such in English company law. Fundamental matters of corporate governance are dealt with in codes, and so they are a creature of soft law, if you will. So even leaving aside the standing issue, there is a sort of lack of legal hook, if you will, by which a shareholder could seek to question the conduct of the board. So shareholder activism in the UK for public listed companies is really a function of the media. Shareholder activists, hedge funds, for example, do not go to litigation to seek to bring pressure to bear on the boards of public companies. They use the media. They will start with open letters to the boards. They will agitate at the annual general meeting, and they will have a concerted PR campaign, no doubt involving professionals, background briefing, the media, and so on, either intended to change the course of conduct of the company, force the resignation of the board or a member of that board. And so it's a fundamentally different way of regulating the governance of public companies in the UK than in the United States. So finally, turning then to civil procedure and what does that have to say about it? Well, there really isn't a direct parallel between class actions in the US and class actions in the UK. In fact, it wasn't until very recent years that there was any sort of mechanism at all by which groups of similarly affected claimants could bring in a group context a litigation in which they could share but in both the risk and the reward of those cases. Why is that? Well, perhaps part of that is the fact that we have a costs shifting system in English litigation. Therefore, an individual shareholder taking on a major corporate in relation to a claim just in affecting their own interest would have a disproportionate costs burden, a disproportionate costs risk were they to lose in that litigation. They would be left with all of the costs of the corporation. And generally speaking, that's why we haven't had mass actions over time. We also didn't permit the funding of litigation by third parties until very recent years. And again, that's a major distinction between the practice of litigation in the UK and the practice of litigation in the US. The economic drivers, the fundamental market for mass claimant claims just wasn't there, even leaving aside the lack of sort of civil procedure infrastructure. Now, in recent years, all of that has opened up. We do permit litigation funding. There are various procedural schemes that, while not class action as such, do permit a certain organised approach to litigation, but nothing like you see in the US. And then finally, we have a public policy around consumer cases in any event, and certain cases, particularly those under a particular financial value, cannot be the subject of mandatory arbitration.
Thank you, Sophie. Pedro?
Sure. I'll still try to provide more context to why class arbitration became a hot topic in Brazil. So since 2014, large corruption investigations and disasters gave rise to the filing of a series of securities class actions against Brazilian publicly traded company before US courts. These cases were filed under Rule 23 of the Federal Rules of Civil Procedures and the General Anti-Fraud Provision of US securities laws, Section 10B of the Exchange Act, and Rule 10b-5 of the SEC. So giant mining company Vale, the Brazilian state-controlled company Petrobras, the Brazilian bank Bradesco, an energy state-owned company Eletrobras are examples of companies that have faced or are currently facing securities class actions in the United States. These companies participate in ADR programs and are therefore foreign issuers traded in the New York Stock Exchange. In general, plaintiffs in these cases assert US securities loss claims of ADR holders and bondholders that fall outside of the scope of the arbitration agreement. For purpose of background, I'll comment on the main features of these US securities class actions, and I'll ask David to correct me if I'm wrong on any of these points. So under US securities laws, the company, the issuer of the securities, is liable for share price damages arising from material misstatements or omissions under Section 10B of the Exchange Act. Although obvious in the US, this is not necessarily true in Brazil and other jurisdictions. There's strict liability for material misstatements or omissions in registration statements in securities offerings under Section 11 of the Securities Act. And investors don't need to establish loss causation, which is the causal connection between the fraudulent statement made by the issuer and plaintiff's loss. Defendants bear the burden of proof of showing an absence of loss causation under Section 11 of the Securities Act. There's also presumption of reliance. Reliance is the requirement that established that the plaintiff actually relied in the fraudulent statement in making its investment decision. The US Supreme Court case Basic v. Levinson, dated 1988, revolutionized securities litigation practice in the US by creating a presumption of reliance in favor of investors under the fairly controversial fraud on the market theory. Such presumption is what made securities class actions possible in the US because the reliance requirement was previously understood to be inconsistent with Rule 23, which requires that question of law or fact common to the class predominate over any questions affecting only individual members. Judgment is binding on all members of the class that do not timely opt out, so classes become extremely large. Claims are resolved by jury trial in general, and settlements are, in practice, the rule. Given the risks involved, even very weak cases settlements are pursued regardless of the strength of the defendants available to defendants. Only 0.2% of all cases that survived a motion to dismiss or a motion for summary judgment actually reached the final judgment since 1996, which was the passage of the PSLRA. Finally, there's a record of extremely large attorney's fees payouts from 2009 to 2018. Settlements have generated around 8.8 billion in fees and expenses, according to Narrow Economics. And since the passage of the PSLRA, that number goes to almost $20 billion. So against the backdrop of this new trend of US securities class actions targeting Brazilian companies, we started seeing attempts by certain Brazilian practitioners to selectively import features of US securities laws and US-style class actions to Brazil. But because of the arbitration agreements in the bylaws of most of the country's publicly traded companies, those claims and any claims must be resolved by arbitration. In this context, the availability of class arbitration became a hot topic. In my view, class arbitration is not available under Brazilian law today for a variety of reasons, which I'll try to explain in a few moments, which are not very different from the UK approach to this issue. But I'd like to talk a little bit about the merits of securities claims against corporations in Brazil. Differently to US securities laws, the long-standing view under Brazilian corporate law, confirmed by a very recent Brazilian Securities Commission ruling, is that damages for loss of stock value do not give rise to direct claims by investors against the company. Our corporate law system of liability deliberatively chose to make controlling shareholders, officers, and directors liable for those types of damages in case they exercise their controlling rights improperly or failed to act in accordance with their duties of care and loyalty. And remedies available to investors are derivative suits. Investors' losses are compensated indirectly to compensation paid by the company, with monetary reward paid to the winning plaintiff and his counsel. Our system chose to preserve the wealth-generating entity, which is the company that pays taxes, creates jobs, and helps develop the economy. One could question, of course, whether this structure addresses the two main concerns in liability systems, which are compensation and deterrence. I think it does. It targets the people who actually made and probably benefited from the false statements, and not everybody else. And it does not result in meaningless pocket shifting among shareholders. In addition, in most cases, the deep pockets of controlling shareholders will be available for harmed investors if actual recovery is a concern. But the substantive law questions relating to today's discussion require a full-day symposium.
Thank you, Pedro. Indeed, that's a hot topic right now in Brazil. I think we have different views on several issues that we can definitely discuss later on with the whole audience. I think we definitely need to hear how Germany is dealing with these issues.
Yeah, thank you. Well, in Germany, as in many other continental European countries, there is no tradition of class action, much different from the US. And that also has good reasons, because it was always held possible and available for parties in disputes to assign their rights and their claims to a third party, to someone else, and to have that third party act as a representative for them in some form of representative action based on a private agreement amongst these individuals or these individual companies. So my perception is that there was not really perceived any need to engage in any state-enabled class action possibilities under German law. And interesting enough, this possibility was used quite broadly, especially recently, to assign rights and to use representative action by the transferee. For example, to pursue cartel damage claims is really a business in Europe, using that manner to transport numerous parties' claims channeled through one party who is assigned these rights and then takes them either to court or to an arbitration, whatever the case may be. However, just as Dave has explained from the US perspective, also in Europe, there is a tendency and a trend that there might nevertheless be a need for some form of amalgamation of claims, as you have coined it. And this trend has led to a few initiatives on the level of the European Union, and dropping down from these initiatives, also Germany has enacted a few laws which nevertheless install some form of collective redress, which is not really class action under the US principles or compared to the US principles, but which goes a little bit into this direction. So first of all, there was the Act on Model Case Proceedings and Disputes under Capital Markets Law. So under this law, in certain capital markets issues, there is a possibility for class redress. And then there was second law which allowed this mass redress in disputes about certain consumer claims. The notion being here again that the consumer, just as Dave has pointed out, often is perceived to not be in a good position to bring his claim or her claim individually and needs some form of assistance in order to jump over the threshold to take the case to court in the first place. And that were the first initiatives under German law. However, in 2018, the legal landscape changed a little bit in Germany, because in the German Code of Civil Procedure, there were additional procedural rules enacted, which now allowed for model case proceedings for affirmative action for special interest groups. Affirmative action meaning that these interest groups can take questions of general interest to numerous groups of claimants from parallel cases to court, and to have the court affirm and to establish certain preliminary issues which may be of interest to all of these possible claimants. For example, is there a claim on the merits under certain prerequisites? And if this is established, then all the individuals falling under that action can deal with that question as already resolved, and they only need then to take their individual case to court in order to establish the quantum of their individual claim. The first test case for that law, and actually some say the law was enacted specifically for that test case, is the large diesel case in Germany against Volkswagen and other car manufacturers. Some of you may know, in Germany, if you meet a lawyer today, the first question is, do you do diesel? Because everyone does diesel at the moment, so all large German law firms are engaged in claims against or for defending any of these large car manufacturers. So this is slight tendencies to change the landscape a little bit. Bridging that to arbitration, there is almost no discussion about class arbitration in Germany, at least if you tackle it from that perspective. However, from a different perspective, there are some initiatives which could lead away or show a way into a discussion to class arbitration. This has to do with the court decisions that I cited in the first round. Based on that, the German Arbitration Institute, they enacted already in 2009 a set of rules, the so-called supplementary rules for corporate law disputes, and they are apt to address the requirements that the German Federal Court established for disputes about shareholder resolutions, which I elaborated on earlier, in a set of rules, and tries to accommodate these requirements. And this is quite interesting because it allows corporations to, by enacting these rules, to accommodate themselves with these requirements from the court, and thereby to allow also corporate disputes within that company to be dealt with in arbitration. And there is quite innovative and interesting stuff within these supplementary rules. For example, those of you who may have followed the discussion in the US may have come across the question whether an opt-in or an opt-out mechanism should prevail in these kinds of dispute. If I understand it right from the US perspective, the tendency there is to say that an opt-out mechanism is sufficient, meaning that if shareholders are generally covered by an arbitration agreement within bylaws and have the right to opt out of that, this is sufficient to establish consent to arbitration. The DIS supplementary rules take a different road. They say, no, we need to have some kind of opt-in consent. So the rules provide for either the claimant and or the respondent to invite so-called concerned others, that may be other shareholders, maybe organs of the company, maybe whatever other parties within the realms of the company, to join the arbitration. And then they have the chance to opt in. And if they fail to do so, that is being dealt as a waiver of their rights to participate in the arbitration, and also a waiver, and if they participate, if they do participate, it is also a waiver of any rights against the composition of the arbitral tribunal. So this is quite an interesting feature within these rules, and there are other features that I will tackle in the last round of our discussion.
Thank you. So before moving to our last topic, that is actually the challenges we face once we have a class arbitration, I'd like to open the questions to the floor. Guilherme.
I think when we talk about class action in Brazil, there is an important distinction that should be made because it has nothing to do with class action in the United States. And I think perhaps two aspects should be emphasized here. The first one, when it comes to adequate representation, in the United States you have to go through a certification process. In Brazil, the standing to sue is provided by statute, and statute actually names the players that can file the so-called class actions. I'm talking about the public attorney's office, the public defense attorney, associations, unions, and so forth. So you cannot have one individual in Brazil file a class action allegedly representing other individuals in the same position, because that doesn't happen, doesn't exist in Brazil. So I think that party representation. And the second thing is res judicata. In the United States, once you do not opt out of a class action, res judicata cuts both ways. So if the class action, if you lose the class action, the individual cannot file a lawsuit. In Brazil, that does not happen. We have a very idiosyncratic system in which an individual that is supposed to be representing a class action, so-called class action, if the class action, the plaintiff loses, the individual may still file suit. So it's not compatible with our system, a class arbitration, unless we had some new statute providing that res judicata could cut both ways, provided that adequate representation should be certified by an arbitrator. Before we do that, it's simply not possible. That's just a comment. I think it supports your position.
Yeah, and it totally helps me with my next topic.
Let me just quickly comment on that from the German perspective. Also, the laws that are cited in Germany, they do not allow individuals to take class actions to court, but they specifically name certain interest groups which are eligible as claimants.
Do we have any other comment or question? Well, so that led us actually to our next topic, and I think definitely Pedro should start with it.
Okay.
And I think I do have a question for you that I do agree with your argument based on the merits, but until we reach that, we'll still have to deal with a lot of issues when you have a class arbitration until we get to the merits and decide whether these remedies are available or not to certain shareholders. So our last topics, basically these procedural challenges we are facing. First, since we don't have in all jurisdictions a certification of the class, who are the legitimate persons established by law or not, how do we deal with appointment of arbitrators, costs, and also the effects of an arbitral award?
Yes. No, I certainly agree that there are many procedural challenges that must be addressed before we actually reach the merits. And I think I'll start by recognizing that multi-party arbitrations are available and do not face legal obstacles in our system. They are available to all shareholders in a company that has a bylaws arbitration clause. Shareholders only need to organize themselves and file the case together. Naturally, each claimant must prove his or her claim individually, and the award will only be binding on the parties to the proceedings. We could discuss the practical and logistical challenges to multi-party cases, there are many, but they're about the same in every arbitration with a large number of parties, and I'll try to focus on the arbitration between shareholders and the company. First, I have to put it into context. I'll try to summarize what practitioners who support the availability of class arbitration in Brazil right now without specific party consent and without a change in law do propose. They propose that an association of investors could represent or substitute a class of unidentified shareholders in an arbitration against the company, and the resulting award, if rendered in favor of the association, as Guilherme mentioned, would be binding on the company and would benefit all shareholders, even the ones that did not take part in the case. The award would establish the liability of the company for the damages caused in a generic fashion, and shareholders would enforce it individually. The arbitration tribunal, if the arbitration tribunal rules against the association, the award will not have any res judicata or collateral estoppel effects towards shareholders. To put this idea together, they say we could import to our arbitration framework a selection of Brazilian civil procedures rules concerning collective actions, regardless of the lack of party consent in that regard. The first and obvious problem I would like to point out is that the association is not a shareholder and therefore not a party to the bylaws arbitration agreement. But assuming we can overcome this very challenging problem, there are still other more interesting points to discuss. The choice of the procedural law of the arbitration by means of the selection of the seat refers to the arbitration law of the seat and not the local rules of civil procedures. Our arbitration regime is independent from our rules of civil procedure, which includes the collective action regime. The collective action framework is not lex arbitrio in Brazil. It was never intended to apply in arbitration when enacted in 1985 and 1990. Article 21 of the Brazilian arbitration law provides that arbitration will follow the rules in the arbitration agreement, which may refer to the rules of an arbitration institution. And in case the arbitration agreement is silent on the rules of arbitration and does not incorporate the rules of a given institution, the arbitrators will have the power to set them up. With respect to shareholder company disputes, neither the bylaws arbitration agreements nor the rules of the market arbitration chamber provide for class arbitration. To the contrary, the rules of the market arbitration chamber provide that the arbitration would be binding on the parties and on an undefined group of investors. And the whole system has been designed to govern individual and multi-party arbitrations, which are the only forms of arbitration that the market arbitration chamber envisaged back in 2001 and which the parties consented to when enacting the bylaws arbitration clause. One could argue that because the bylaws arbitration clause is silent on rules for class arbitration, the arbitrators could exercise their power to supplement the parties' agreement under Section 21 and set the framework for the case to proceed on a class-wide basis. But the bylaws refer to the rules of the Market Arbitration Chamber, which, as I mentioned before, do not provide for class arbitration, so there's really no gap to be filled with respect to the rules of arbitration. And even if that was not the case, I believe a decision by the arbitrators setting class arbitration rules and establishing that the award would benefit investors that did not participate in the case would be an unacceptable amendment to the rules of the Market Arbitration Chamber and a major deviation from the parties' arbitration agreement. That will very likely lead to serious challenges to the award under Article 32 of arbitration law. So the bottom line is that absent party consent to class arbitration, in my opinion, there should be no question that an arbitration award can only bind the parties and benefit the parties to a given case. It's also worth noting that our arbitration law was amended in 2015 to resolve controversies that arose since its enactment in 1996, and nothing was said at all about class arbitration. In addition to that, and that is a specific challenge I see for securities disputes, before Basic v. Levinson that I mentioned before, the US Supreme Court case, investors asserting security fraud claims in the US must establish falsity, materiality, scienter, reliance, loss causation, and damages. Out of these 5 elements, reliance was understood to be inconsistent with the predominance requirement. That would be the same in Brazil. Assuming we could apply our collective action system in arbitration, which I think we can't, predominance is also a requirement under our collective action system. And in our civil law jurisdiction, creating a presumption in favor of the plaintiffs would require a specific law. I'll stop right now and I'll make some more comments later. But thank you very much.
Oh, thank you, Pedro. David, how are these procedure issues tackled in the US? I know you have specific provisions for certification, but you could address.
Sure. So first, let me start by just sort of stating one important point of clarification from my last intervention, which is I mentioned that in the context of shareholders bringing claims against broker-dealer companies or companies in which they invest, that there is a prohibition on class action waivers, right? And that's true. But there's also another interesting corollary, which is that FINRA, which is the agency that, again, is within the umbrella of the SEC and oversees regulatory compliance and enforcement of broker-dealer companies or companies that issue public stock, they have within their code a prohibition on class action arbitration. So when you put the two things together, what does that mean? Investors in public companies, if they want to bring an individual claim against a broker-dealer company, they can do so, but in arbitration, but they can't amass those claims in arbitration. They can't have class action arbitration of those claims. If they want to do a class action, hence the prohibition on waivers, they can do it, but they have to bring those claims in court, okay? So when you put it all together, what that means is, again, in the context of the specific sector that we're speaking about in this panel, investors have the ability to bring class action claims against companies in which they invest or broker-dealers which issue them stock in those companies, but they must do so in court. If they want to bring an individual claim, generally speaking, their agreement with the broker-dealer from whom they purchased the stock will require them to arbitrate that claim individually. I hope that makes sense to everybody. It's a little bit complicated. And the particular FINRA rule that the controls here, FINRA rules of control here are rules 12204A and 13204A, if anybody's interested. Okay, now to the question at hand. Yes, so if we're in the context of a class action, a securities class action, we're in court, as I just said, and there are a number of requirements, okay? In order to bring a class action, and this is under the Federal Rules of Civil Procedure, one has to show that the class is so numerous that joinder of all members is impracticable, so we can't be talking about 20 people or even 30 people, we have to be talking about thousands of people. There are questions of common law or fact, common to the class, the claims or defenses of the representative parties, i.e. those that are bringing claims and those that will be defending the claims are typical, and the representative parties will fairly and adequately represent the class. That means the class representative or representatives have to be truly representative of the investor class on whose behalf they're bringing claims. That's step one. Step two, then you have to show one of three other factors. I won't get into all of it, but the one that's most utilized is that the common questions of law or fact predominate, i.e. there are more common questions of law and fact in relation to the claims and the defenses than not. And that's usually the place where that is litigated. So what happens procedurally? First of all, these things are usually driven by lawyers. Lawyers go out and they try to find plaintiffs who have particular claims. Literally, lawyers, there are in the U.S. there are lawyers and law firms who specialize only in bringing class action claims, and they are looking for situations where these sorts of cases can be brought. And so, for example, if there's a company that issues a correction in relation to a public filing, there are lawyers and law firms that are literally combing through those, looking for the possibility of bringing claims against these public companies for making material false representations in relation to a public filing. And so when you find them, then these plaintiffs, lawyers usually will go out and try to find representative plaintiffs, and then they'll bring a case in court. And there may be competing cases. There may be a case brought in New York, and another one in Florida, and another one in Texas, and they're all trying to represent the same class. And so really, first to courthouse is number one rule. The faster you get to the courthouse, the more likely that you're actually going to be able to get your class certified. And two, you have to do your homework. You have to make sure that you really do have a representative class plaintiff or set of plaintiffs, and that you can really meet all of these requirements. Usually there's a very long litigation at the beginning of a class case over whether you in fact meet all of these various requirements under Federal Rule 23, and from both a plaintiff and a defense perspective, the name of the game is getting the class certified. If you can defeat class certification, generally speaking, as a defendant, you're very happy because it means that the majority of the claims will go away for the very reason that usually those claims are too expensive to pursue on an individual basis. If you can get a class certified, plaintiffs and their counsel are very happy, generally speaking their counsel, because what that means is that the company's probably going to settle. And so it's then it's a question of taking discovery, making sure you've got enough evidence to show that there is a material misrepresentation, for example, in the context of a public company filing. And usually companies, when they're in that scenario, don't want to face the risk of going to trial and having a jury issue some incredibly large award against them, and so they'll settle. So that's usually the name of the game, class certification. I'll stop there.
Thank you. Sophie.
Well, so as I've already explained, class action and arbitration in relation to public companies really isn't a thing under English company law. There are sort of a couple, I suppose, of pragmatic reasons in addition to the legal reasons and structural reasons that I've already explained why I just don't think it would take off in the UK. So the first is a sort of pragmatic or practical one. So when it comes to public companies, typically the bylaws, the Memorandum of Association, the Articles of Association, these tend to be based on I don't want to say sort of common form, but that there is a standard form as such, a default form as such of those essential constitutional documents, and none of them contains an arbitration provision. So it's never in there from the beginning for people to be sort of thinking about. And then sort of ask yourself what would happen in a negotiation when people are sort of thinking about how to develop those articles, and someone sort of says, well, why don't we put an arbitration clause in? And then the discussion begins, well, what's that going to look like? What's a class action arbitration going to look like? Well, there is no such thing. So it's very, very difficult, I think, for them to conceptualize what that would look like. So you can't, realistically, you just don't see that happening. But the second, and I think more fundamental perhaps, is this. It's not obvious why arbitration offers any particular advantage in this sort of claim. When you think about the typical reasons why people go to arbitration, they include such features as choice of arbitrator. That fundamental choice is so important, particularly in the corporate world, the commercial world. Well, in the context of a super mass class action, it just isn't realistic to think that everybody is going to agree on the arbitrator. Just the basic mechanics of trying to get an agreement just isn't going to happen. So the institution is likely to make that appointment. So no choice of decision makers. The second is expertise. We like to go to international arbitration, but particularly for certain kinds of contracts, because we consider that there are arbitrators out there in the world who have particular skills to bring to bear in certain kinds of cases, whether it's gas pricing, long-term agreements, whatever that might be. And so far as English company law is concerned, there is such an enormous body of law and procedure that resides in our company courts and in our company judges that arbitrators aren't really offering any kind of alternative to that. And if anything, if they haven't practiced in that system, then perhaps they don't really have the requisite experience or knowledge. And then thirdly, enforcement. Enforcement is a key reason why we tend to go for arbitration rather than litigation. The idea that we can enforce in each and every one of the New York Convention contracting states. Well, when you're dealing with an English company, it's already there in the jurisdiction. Its assets are there in the jurisdiction. So arbitration is not offering any particular enforcement advantage. And then finally, publicity. So insofar as arbitration is confidential, it doesn't really suit this type of action. Generally, a case like this, you would want it to be funded by a litigation funder, and you want it to be settled quickly. And the way to go about doing that is by gathering as much publicity as possible and forcing an early settlement. And those dynamics just aren't available in a private arbitration. So for all of those reasons, and no doubt more, I really don't see class action arbitration taking off for UK public companies.
Thank you. How about Germany?
Yeah, as I said earlier, there is, as in the UK, no practice and no tradition of class action arbitration. Therefore, there are no current legal challenges or aspects. But if I were to think about the main challenges that one may face when thinking how to install such a system, I can think of 4 main issues. First of all, consent. I think we should not forget that at the flip side of the coin of the question whether something is going to arbitration or not is always the exclusion of the possibility to take the case to state court jurisdiction. And this is quite a serious issue. So when you want to tell someone that they are excluded from taking their case to a state court jurisdiction, you need to find good grounds for that. So I think the question where you can find the consent to arbitrate in these kinds of dispute is an issue. I talked about the opt-in and opt-out systems, so I think one needs to get around that issue and make up their mind what to want to choose. And as I said earlier, the supplementary rules for corporate disputes of the German Arbitration Institute, they chose the opt-in model. But let me add that these are private rules by a private arbitration institution. This is not law. Second issue, appointment or choice of arbitrator, as Sophie has already touched upon. The DIS supplementary rules, they tackle that by saying that a party and all those concerned others which that party has designated to be included into the arbitration shall jointly agree on the arbitrator with whom they wish to choose. If they don't agree, then the DIS as an institution will step in and will appoint that arbitrator. But what is, in the absence of an institution being at play, an ad hoc situation? If you think about a legal concept establishing class arbitration, one would come up with an idea how to get the arbitral tribunal in office, absent agreement amongst these different parties and class members and so forth. So that's the second issue that I can think of. Third issue, which was also already raised by Sophie, is the issue of confidentiality. If you are able or even forced to invite whomever external third and fourth and fifth parties to your arbitration as concerned others, as the term is coined under the DIS supplementary rules, then this by nature breaks up the confidentiality, at least to a certain extent. Suddenly certain additional shareholders which may not have been at the core of the dispute get knowledge about that. They even invited to take part in the hearings and so on. So there is, of course, a question of confidentiality here, and that would be the third issue that I think would need to be tackled. And then finally, fourth is the cost issue. Whenever you are party to a dispute, there are two aspects of costs. One is that you expose or may expose yourself to the risk to bear the costs of the tribunal and or the other parties if you lose the case. And the second is the issue that you may be interested in a reimbursement claim for your own costs, which you incur to either take the claim or to defend against the claim of another party. And also that would need to be tackled. In the DIS supplementary rules, only the second issue is tackled. It says that if you do not join the arbitration as a concerned other, although you have been invited to do so, then you use your claims for reimbursement of your own costs. It doesn't say so much about the risk of being exposed to the costs of others, but if you're not joining, you're not a party, and therefore you will also not bear those costs. But I think the cost issue is the fourth issue that would need to be tackled.
Thank you, David. Well, I think this is a hot topic in the moment and they're still developing. There are a lot of open issues, as you could see. So I'd like to invite all the audience to make any comments or questions for any of the panelists. Cesar?
Hi, I'm Cesar Pereira from Brazil. I just have a quick question for Pedro. I don't think we discussed this curious statute that we have in Brazil of 1989, a very short statute that grants the Public Prosecutor's Office standing to file our Brazilian-style civil class action to defend the capital markets, right? And that statute was left forgotten, as far as I know, for many years until, as you mentioned, around 2014, 2015, we started having discussions about the effects of corruption in companies and damages to minority shareholders. My question is specifically, sure. What is your position about that statute? Does it make a difference that we have that statute? 1989, that's before we enacted the first laws, as far as if I'm not mistaken, the first laws dealing with Brazilian-style class action. That was in 1990. It was before our current Arbitration Act, 1996. And so can we bring that 1989 statute to the current legal framework and get something out of that to use in terms of class arbitration? Does that statute mean that we may have parallel proceedings? Shareholders go to arbitration to deal with their individual claims, and the Public Prosecutor's Office may go to court to deal with that in a more collective manner. So or is that repealed implicitly, and we can forget about that statute again?
Yeah, I think there are many ways to address that law 7913 of 1989. But my opinion is that it sets procedures that should not apply in arbitration. The parties shall govern the arbitration procedures, as I commented earlier. you cannot import. It looks like we agreed on the question and the answer, but that was the topic I did not have time to address. But I think you cannot import the rules of procedures to arbitration without express consent to the arbitration agreement. In any event, Article 1 of that law says it grants the prosecutor's office standing to file the action. It does not mention an association or any other entity authorized to file collective actions in Brazil. There's a generic reference, general rule that makes a reference to the general collective action law in that very short law. But I think the general rule in Brazil is that the holder of the claim shall file the action on its own name. Asserting claims on behalf of others is an exception that requires legal authorization. I think that reference in the end of the law to the general collective action law is not the express authorization required to grant someone other than the prosecutors standing to file a lawsuit or an arbitration, much less an arbitration. I think that's basically the main way I see this. It's a very short law.
Well, actually, I would like to see David's view on that point, particularly not only here, but before Pedro argued that the whole system of collective actions cannot be imported to arbitral proceedings. How is that seen in the US? When you have a class arbitration, do you apply the same procedure rules of class actions for certification of other? Are these imported in the US?
So I'll start by saying I've not handled one of those myself. Having said that, my understanding is that the general framework for pursuing the class claims in arbitration tend to follow the same guidelines that are in Federal Rule 23.
And do the parties need to specifically agree on that, or implicitly?
Yeah, I am not sure is the answer. I don't know if anybody else in the audience knows, but I'm quite not sure. Because I'm not aware, so first of all, federal rule of civil, it's a federal rule of civil procedure. It only applies in federal court. And of course, arbitration is a creature of consent and contract. So absent the arbitral agreement, providing that one has to follow those procedures, then I think it's probably left up to the discretion of the arbitral tribunal, who may look to that for guidance, but isn't necessarily bound by it.
Yeah, I would say so too. Do we have any further questions from the audience? Peter?
Yeah, I have a question also for Pedro. Let's leave for the moment aside collective arbitration and focus on multi-party arbitration. I think from an institutional perspective, the major concern is that we might end up with conflicting arbitral awards on more or less the same facts and legal questions. And this is also, I would say, a problem for the corporation because we have the equal treatment principle of shareholders. Do you think it makes sense? And I think the German solution will not help in Brazil because we don't have in the Civil Procedure Code effecto erga omnes. So we have a quite interesting norm on conexão, on consolidation of proceedings. Pedro, do you think it's helpful if institutions work on trying to transpose this mechanism that we have in the CPC to arbitration, conexão?
Yeah, I think there are many challenges, but the way you can address that is that conflicting decisions is a problem, but it exists and in other areas. And I think on these types of disputes, there are so many individual questions. For example, reliance, which would probably be a loss causation analysis in Brazil, a causation analysis. That's an individual question, and I think it may well be that very similar cases will have different results just because of the individual questions that will have to be addressed by these arbitration tribunals. But that's something very interesting to think about, and if you guys have a proposal on how to address it, that would be awesome.
Well, and I think that will happen not only within the same country, but now we have, for example, as Pedro mentioned in the beginning of his presentation, same companies having shares all over the world, and you might have litigation or even arbitration in different jurisdictions coming to different conclusions as well. So it's kind of hard to avoid maybe conflicting decisions even within the same company because of being trade worldwide. So unfortunately, I think our time's over. I thank you all for staying until the end of the presentation, and I would ask a round of applause for our speakers.